Record is running. Good evening, ladies and gentlemen. For the record, the court has before it today Supreme Court number 2002, People v. Doe. Previously, we heard a pretrial motion to suppress and motion in limine as to a couple of key issues in the case. The parties are aware of those rulings, but so I won't repeat them now, but today we are now here for trial. So, before we get started, is there anything that I need to be made aware of by the parties? Okay, hearing that as a no, we're going to go ahead and get started with opening. We're going to go ahead and... Yes?
Yes, Your Honor.
Okay, well, go ahead. Alright, yeah, arrest this guy and charge him with...
How is he back already?
Hey, I just want to say this guy didn't do anything wrong whatsoever. Please let him go.
If he runs back there, you're gonna have to shoot him, Your Honor.
You arrested him because he's black, is what you guys did.
Your Honor. Switch
He didn't do anything at all. He didn't do anything wrong.
Do not get close to the judge.
Just tase him. Just tase him.
Where the fuck did Peralta go?
He didn't do anything wrong.
Can I just please?
Your Honor, he's
Just
trying to
give me
rush
permission.
This worked before.
Something.
Let's see if it works now, Your Honor.
Alright,
Permission
just
to beat
let
this
me
man's
shoot.
ass.
No, just...
I take him out. Take him out.
Please let him go. Your Honor, please let him go. He didn't do anything wrong. Please, Your Honor, please let him go.
Oh my god.
Bro!
Your
Oh
Honor,
my
you gotta
God.
please
Threat to my
listen
life.
to me. Let him go. No,
Threatened.
Finally.
Your Honor, please let him go.
Okay, let's...
I'll be
Well,
right
now you get to wait
For the
in
record,
cell
the
until I
continuous
get out of
man's
court.
name is... Holy shit, holy shit.
Your Honor, please
Simo
let him
Geronimo
go.
Hannibal Sawyer?
Okay, so you're gonna be held in the cell until it's over, and then I'll process you.
Oh my God.
Alright,
Get him.
let's,
Feel free to save that for your record later.
yeah,
I'll
I
be good.
will.
I'll be
Okay,
good.
let's go ahead and get back on track here. Before that catastrophe just took place, sorry, I'm gonna need a second to recover from the near brain hemorrhage I just had. It sounded like the prosecutors were going to ask something. Do you remember what that is, or am I just completely off the mark? And
I don't remember. I'm not gonna lie.
Okay, that's fine. In the meantime, we're going to move on to opening. So, we're going to hear from the state first, then the defense. As some of you may know, I do reclose, but I don't think we'll be hearing closing arguments today, or we might, but it would be substantially later. Anyway, we're going to go ahead and get started inviting the prosecutors up to initiate their opening.
Fuck. May I enter the well, Your Honor?
Yeah.
The notes I sent you said you don't have to ask to do that.
Oh, you kept the
Oh,
notes.
fuck,
from my-
I
Oh,
would've-
you kept the... Yeah.
Alright. The case is obvious here today. The DA, Chief Counsel, and officer arrested in jail. May I wait till the, thing ends? The defense and pretrial. Sorry. The defense have failed to demonstrate how there is a lack of reasonable suspicion and probable cause to the issues that are presented here today. They have not demonstrated that in the motion, which was mentioned beforehand.
Hold on, we're not gonna.
And
we're not
additionally-
gonna hear
We're
argument
not gonna-
about
we're not
the
gonna hear ar-
motions. I just want you to give your opening statement for the case.
Of course, but can we bring it in?
No.
Okay. Defense has failed to demonstrate we have violated any of the roots of cause as to in this case. We are primarily focused on the fact that we identified them, the slang that they used, the Hello?
Yeah, I can hear you.
Okay. They failed to demonstrate any of the issues that they have presented forth to the court. We have a litany of witnesses who can demonstrate that they have caused problems for the city as a whole. They have failed to demonstrate that they are not a problem upon the municipality. They have not demonstrated that the affidavits which they question are faulty. They have not, and we would like to present that we have a case which will convict them at trial. We have 3 affidavits. We have photos of the evidence, and we've already disproven their allegations in the pretrial motion. What we're gonna prove today is that they failed to not only adequately demonstrate why our clients, in this case, our witnesses, did not meet those standards, but also that they failed to show why they were not prejudicial and why their substantive testimony outweighs the weight of the evidence which is presented to them. It's a simple case. They didn't prove it. They're not going to be able to prove that their client not only did not possess Quaaludes, but also that using the slang in order to identify that potential criminal activity in this case would be sustainable. And we wish to ask the court to consider, in this case, why is it that they primarily focus on prejudice when that's not even a factor considered in the case itself? They can't prove that we will confuse the judge, not the jury in this case, because, but why they can't disprove the judge, you know what I'm saying? Why they cannot prove that the jury in this case, they can't prove that their client was prejudiced. It's that simple. I would like to ensure that the courts know we intend to prove this case today. With the evidence we have, the affidavits we gained, they will not be able to prove that case. Thank you, that's it.
Okay. And then I'll hear opening from the defense.
The district attorney, of his own volition, followed the defendant and
Wait, hold on.
persecuted the defendant.
Sorry, I thought main counsel was Mr. Edson. Is that?
Yes, Your Honor, main counsel is Mr. Edson. However, as you know, Mr. Edson is very new.
Okay.
This is his first trial. I will be participating as the speaker. The way that it will be divided is I will be doing the first 2 witnesses. Mr. Edson will be doing the final witness in terms of cross-examination, and I'll be giving the open. Mr. Edson will be giving the close. The reason why is to give Mr. Edson a chance to view what this looks.
No, that's okay. I just wanted to make sure. I just wanted to make sure I knew what was going on. Sorry, continue.
The defendant, while operating in his daily routine, had the district attorney, Henry Collins, outside of the scope of his job, persecute him and follow him in his vehicle, along with off-duty officers. They were not operating under the color of law. However, they initiated an unlawful arrest. They had no reasonable suspicion or probable cause. They were operating off the assumption of the district
Look,
attorney.
I don't want to interrupt
You
you
will hear.
again, counsel, but I don't, and I can't make this clear enough. I don't want to hear anything about probable cause or anything like that. That's all stuff that we've already discussed. Okay? Let's just talk about. Yes. Let's hear the trial
Well,
about.
I will,
about the facts
Your
today.
Honor. Yes, the defense plans to bring up how officers did not have this in their testimony. We'll have them
Okay, and you can attack
testify
that
to
as
that.
not making reasonable doubt, but you can't testify about, or you can't have them testify about the probable cause issue, because it's not for the purposes of this litigation now at this point. It's beyond the scope, okay?
Understood, Your Honor.
Okay, thank you. Sorry, I didn't mean to interrupt. It's just, I want to make sure that we're not confusing the issues here.
Officers, while off duty, in the district attorney's personal vehicle, camped and were waiting at the casino. You'll hear in their testimony today that they were waiting and watching. While inside their vehicle, they saw the defendant and another individual enter the defendant's vehicle, privately owned, private property. And upon inspecting them for a moment, the officers then initiated a seizure, ordering the defendant and the other individual to hop outside of the vehicle, and subsequently arrested them. At no point in time did the officers. I apologize. At no point in time did the officers see a traffic violation that is not argued today, or causes of such. But in terms of the officers' operation, they searched the defendant's personal vehicle, and they also searched and seized the defendant's person himself. We are here to argue that they did not have the right to do so, that it was a violation of the defendant's rights, and that the defendant should not be guilty of these charges, as the officers were operating outside the authority of law, and it should have never taken place. That is all, Your Honor.
All right. We're going to move on then to the presentation of the evidence in this case. We'll start with prosecution's first witness and their case in chief.
Defense would like to call up, hold on.
Defense?
Defense?
You're the
Defense?
prosecutor.
Oh, sorry. My apologies.
Oh my god.
One
You
request,
know, I
Your
usually think
Honor.
it's prosecution versus defense.
Well,
May
what's the
the
request?
defense request that the witnesses be in a separate room when they make their testimony?
Yes. Federal rules allow for that. So who are you calling first, and the other one will step out of the room? The other ones will step out of the room.
Rossi.
Oh, yes, sorry, apologies. We'd like to call Counsel Joe Bentley.
Okay. All of the other witnesses, you are instructed to leave the room. You are not permitted to discuss with one another this case. In fact, you should be in separate areas while you wait.
Your Honor, does that include the expert witness, as he did not submit an affidavit for this case?
Well, hold on. Then
no.
he's not going to be testifying.
I am confused.
Yeah, if he's not been disclosed, and the substance of his testimony hasn't been disclosed.
He's
He's been
listed
you guys
as.
talking about me?
No,
we're
not
talking about
you.
Jetty. Your Honor, he's been disclosed on the witness list as an expert
Yeah.
witness in criminology. He was also at the scene, but I
was
do
also
not-
on the
The
evidence
scope of
exhibit.
his
Okay.
expertise has also been disclosed.
Okay, so in terms of the witness separation issue, I'll be clear about that. Expert witnesses are allowed to remain in the courtroom per the rules. It's people who are necessary to the claim, and that has been interpreted over the course of a long series of case law, not to include even key witnesses, but it does include experts. So, he can stay in the room,
Yes, Your Honor.
but the lay witnesses need to be apart.
Okay, then
Yeah,
the lay
Stand,
witness
Your Honor.
is out of the room.
Okay, then we're good to go.
Yes, just to be clear, it sounds like the expert witness was intending to testify on more than just his expert opinion. If that's the case, well, we object to that. They're only entered as an expert witness. They should only be testifying to their expertise.
That is not the case.
of the given-
He's only going to be testifying to his expertise.
Okay, well, we'll resolve that
Okay.
issue when we get there, but let's not start tying nooses to hang people we don't even know exist yet. All right, proceed with your direct examination. Oh,
I know the
sorry,
drill,
hold
Your
on.
Honor.
Let me do the.
Your Honor, you gotta swear me in.
Yes, I know. Give me a second. It's been a long day. Okay.
I understand, Your Honor.
That it has.
All right. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God, under the pains and penalties of perjury?
Yes, I do.
So sworn. You may proceed with your direct examination.
I'm waiting for the prosecution to ask
May I enter the well, Your Honor?
Yes, I've said you
You
don't need
have
to.
to ask that.
Some judges
Hello?
make you ask. I'm not so formal. But yeah, you don't need to ask for me. You can just walk into the well as long as you're not choking up.
Why was a World War II era Wehrmacht soldier in here for a second? What the fuck?
I think
It
that's
is what
the
it is.
antipsychotic meds, but alright, let's get this thing going.
Okay, so where were you on the? Sorry, let me ask. What's your background?
All right. For this case, I was the chief legal counsel of the NYPD. My duties involve, but are not limited to, auditing officers' activities as well as preventing lawsuits. However, at this time, I was not doing either of that. I was simply riding along with Henry Collins, who was a good friend of mine. I was in the passenger seat. I was not performing any counsel duties at that time. I was simply a witness.
Gotcha. What were you doing on the afternoon of May? Let me see here. 22nd.
I was in Mr. Collins's, I believe they refer to it as a clown car, but they're also Mini Coopers. I was in the passenger seat, and we were simply going around the city enjoying the sights when we noticed that a few of the operatives' vehicles were out of commission after, I believe, they were already responding to a call, and then their vehicles... How do I say they got despawned, Your Honor? Do I just say they got raptured, or what's the proper way to address?
They've mysteriously disappeared. That's more of a staff thing, but I understand what you mean.
Okay. Yes.
The tow truck game.
And because of that, the district attorney offered them a ride back to the police department. When doing so, we went around the bank area because that was the most direct route. I believe we were coming from the car dealer, if I don't want to be mistaken. However, once we came to the bank area, we overheard the defendant talking about doing a deal with an individual. Because of that, District Attorney Collins took it upon himself to follow along the vehicle until we parked outside the casino. The defendant came up to the vehicle that we were all in and said, "Are you the guy on the phone?" In which none of us responded because we weren't. He then went back to his own vehicle where the second defendant...
Okay. And when you heard the term quesadillas, and you interpreted it as
Objection.
methaquenone,
Sorry, I got cut off. I wasn't done.
I didn't question you, Your Honor.
Okay, hold on. So it sounded like the witness wasn't even finished answering the question, so I'm gonna
Yeah, no.
strike the asking of the next question, and I heard the objection. but we need to hear the witness finish the initial answer, and then we'll see what the next question is, and then you can decide whether to re-raise that objection. Okay, finish your answer to the question.
Yes, Your Honor. After a bit, we were all in the vehicle, of course. It was me, the district attorney, the 3 operatives. I believe 2 of them are present right now. Micah Devins is not present, unfortunately. After a bit, we heard the
Your Honor,
individual
we're gonna
talk about
object to this
quesadilla.
question too.
What is the...
This question that's being answered.
Okay.
It calls for a narrative. He's not answering the question directly. He's answering again the entirety. Not
Seems entirely
So
unnecessary.
what was the previous... What is the pending question right now? Because it's been a minute, and I'll admit the witness has been talking for a while, so...
It was, where were you on this day and what happened?
Yeah, I'm gonna strike everything... Well, yeah, I'm not gonna strike everything, but I'm gonna ask you to break it up in a little bit more smaller sections. But we'll leave
Yes,
the
Your Honor.
testimony that's already on the record as it is now, but the objection is noted. Keep your answers precise to the question, and counsel, please ask more concise questions. Of course, you're able to keep them open-ended, but there is a limit.
Sure, but at the same time, when you ask a narrative question, wouldn't you, or sorry, not a narrative question, but when you ask somebody for explanation of their situation, wouldn't you expect they give a form of narrative that falls outside of the objection?
Yeah, and they should give you an answer that's just commensurate to the question that you asked, and it shouldn't be one that invites the person to engage in the sort of writing of a novel on the stand.
Sure, but don't you interpret how much a person is talking before they get cited for narrative?
Yeah, and I'll say that went on so long that I didn't remember what the pending question was.
Good point.
So we'll go ahead and just break your questions up a little bit more. The objection is sustained, but no testimony is stricken.
Would you like to continue, or do you want to rehash?
Just ask your next question, and if there's an asked and answered, we'll deal with that then. But I think counsel is probably inclined to, since they objected to narrative, they're probably inclined to listen to you break it up a little bit more.
Gotcha. So, were you in a car with Henry Collins?
objection leading.
Correct.
Overruled.
I said, were you in?
Overruled.
Okay, so
Yes, I was in a vehicle with Henry Collins.
what happened while you were in that vehicle?
Like I previously stated, we overheard the talking of a deal in which we followed them to the casino. And by we, of course, it is Henry Collins, the one driving, no officer or myself, took control of the vehicle at any point in time.
That's fine.
Would you like me to
So in regards,
continue?
Yeah, continue. Sorry about that.
Like aforementioned, he asked if we were the guy on the phone. We weren't. He then mentioned talking about quesadillas
Objection
to the
calls for
person that
narrative.
came up.
I agree. I would like.
We're fine.
Could you?
Let's break it up.
Yeah, could you expand upon that? Just give some context to the situation.
In what capacity? I'm sorry, I don't quite understand what you mean by expand upon it.
To the situation that occurred. So someone approached you and said a bunch of words. Then you went to track them. You got to explain that.
No, they did not approach us until we were already parked at the casino.
And was this person shouting on the street?
This person was talking audibly on the street, however, it was first at the bank area where we heard him, and then at the casino when he went up to our car and asked us if we were the people on the phone. Or person.
And what happened after that?
What happened after was another individual, I believe a Mr. Angelo, came up to him, and then the defendant here pat him down for wires visibly in front of us, in which they both got into the vehicle and opened the trunk. At that point, the operatives determined they had enough reasonable suspicion to question him about what was going on. Once they left the vehicle, however, the Mr. Angelo, the other individual, fled the scene, prompting them to detain him as well as question their defendant here. I'm sorry. Upon
Again,
questioning
objection
as well as
narrative.
search.
This is not.
This is
specified
responsive to
questions
the question.
going on.
Overruled.
The objection vague. Then the question was what happened after that. There's a various sequence of events have happened after is what you just
I'd like
said.
to-
This
Multiple
is,
segments
Yeah,
of the story.
again, it's overruled. We'll continue hearing the testimony.
Resume, I assume.
Yeah.
But let's wrap it up.
Both individuals were detained at the time. The vehicle was searched, and they found illegal narcotics, bricks of it, as well as methaqualudes on the defendant's possession.
Gotcha. What led you to this? So when you were talking about Henry Collins tracking these people down, what was it he said to you? Actually, I want to ask that. What was it that triggered the search, the following search, etc.? You know what I'm talking about.
Because of the circumstance of...
Can you restate that question one more time?
Yeah, I'm gonna have to agree.
I
I'm
didn't
gonna have to
interject.
agree.
I apologize. I'm just saying, can you state the question one more time?
Yes. When you went to search that individual, what was the qualifier for the officer exiting the vehicle and going to search these individuals? And
To
detain them?
clarify, I am not an arresting officer. I did not attempt to detain him. I did not give him any lawful order because I
No,
cannot.
just the officer.
Okay. The reason they were being detained at the time, well, they weren't being detained at the time. They were being
Answer calls for
questioned at the
legal
time.
conclusion.
No,
Sorry, what was that?
I am the
doesn't
chief
know-
legal
Oh,
counsel.
and well, here's the thing: is notwithstanding that, it's my job to decide the law, which is why that objection exists. It's some kind of violation of the 700 series of rules. But that said, this isn't a question about whether or not any legal fact did in fact exist, right? It's not a question of what does this law mean, or like was this sufficient for the purposes of probable cause or whatever. This question is probative to why the officers made the decision to initiate the stop, which is completely permissible territory in terms of the expert rules. So overruled.
So, do you wish for me to explain as to why now?
I wish for you to answer the pending question, and if counsel needs to repeat it, that's
Okay.
fine.
No, I remember. The officers reached the minimum standard for reasonable suspicion based on the fact that one of the officers was not only an expert witness in criminology, but everyone in the car understood that quesadillas are street slang for methaqualudes. It is well documented several different NYPD structures as well as previous arrests. Because of that, the patting down,
Objection,
both getting in the
hearsay.
car.
Okay, what was the hearsay objection to?
702. He went from talking about his experience to talking about the documentation and data behind it. It's not an expert witness. Can't talk about that. You can talk about his experience.
Okay,
Yeah,
I could rephrase if need be.
I'm inclined to agree. That is sustained. Also, I'm just going to strike from the record the part of your statement where you said that the officers met probable cause. Because again, I think that is the territory of a legal conclusion. Continue.
Okay. The reason why the officers believed they met probable cause, reasonable suspicion, is that okay, Your Honor?
Yes, I think that's fine.
Okay. The reason why they believed as such was the combination of, to my knowledge and previous experiences I've had, quesadilla is a street term slang for methaqualudes, as well as being pat down for wires, as well as him asking the entire vehicle if we were the guy on the phone, made everyone in the car assume it was a drug deal, which they had reasonable suspicion, in my knowledge, reasonable suspicion to question them about what was happening. Because the defendant, but not this one, Angelo, fled from the police to what they were trying to question him. That gave them, in my opinion, probable cause to detain them.
We don't necessarily need the opinion about the probable cause, but I guess I'll ask a question here.
Yeah.
Is it the understanding, or we don't understand your testimony correctly, that they at least used that as their reason, whether right or wrong, to initiate the stop and to perform the detaining?
I cannot speak on behalf of my colleagues, but you would have to question them, Your Honor. From my understanding, that's what they used. They could have been operating on a minor clue of truth that I don't know myself.
Okay.
But that is what if I was an officer in their position, that is what I would be operating under.
Okay. Continue.
Any other questions, counsel?
No, that was. Oh, sorry. You're asking. Go ahead, prosecutor. Go ahead.
In this situation, when you arrested this individual, do you believe you acted in the capacity of an officer?
No, I was in the car for most of the duration. I stepped out to observe the situation more directly. However, I gave no lawful order, nor put cuffs on anyone, nor attempted to detain them in my own capacity, as that would get the arrest thrown out. I'm not an arresting officer. I wasn't at that time anyways.
Gotcha. And you initiated, or when the officer initiated this arrest, did you ever at any time anticipate that you would be acting in a legal capacity as a
Define
law
legal
enforcement
capacity.
officer?
I have stated before, I was not an LEO. I was not listed as one. I was a civilian employee, so no, I did not expect to act as a law enforcement officer at any time.
Do you consider acting as an LEO to be the same as acting as an LEO?
Can you restate that question?
What did you just ask
I think
me?
I misheard you.
If you are giving directions, let's say, right, and you're trying to get somebody who committed a criminal act, by the way, would you consider that the same as acting in the same manner as LEO?
I'm just
Objection
more confused, honest.
and
Yeah,
objection
I don't know
speculation.
what the question is. I don't think it's speculation. Well, I don't know what it is. So I'm gonna overrule
Okay,
it. until
may I
such time as
reiterate the
rule it,
question?
Until such time as I. May you what? May you what?
Do you, sorry, may I reiterate the question?
Absolutely. Go ahead.
So, when you, let's say, gave orders to people or whatever, do you think that is in the same format as when an officer orders somebody, detains them, cuffs them, brings them to a jail cell? Would you say that is the same as when you
Okay.
just said,
Okay.
hey, you shouldn't engage in this?
I understand what you're trying to ask. However, for the fourth time, I
Objection
believe I
relevance.
cannot give lawful orders.
Okay.
Right,
I just heard
so
relevance.
that being-
I just heard relevance. So kind of expound upon that defense.
Well, would,
My objection.
I want to hear
He-
what the I want to hear what the objection is from defense in full, because I'm not sure I understand the relevance objection.
Yeah,
So, if a person-
part of it.
Hold on. Give me a second, prosecutor. We're listening to an objection from defense right now.
So the objection
so
was
the-
relevance. Maybe I misunderstood the question. However, I fail. This is from what I understand, this is asking the opinion of the witness to the scope of a law enforcement officer's job, and
No.
acting within the law enforcement officer's job, and seeing how that's relevant.
Well, maybe because counsel for the prosecution just said no, so maybe you can help explain what really. Just tell us what your question is trying to get at here.
Of course. So, why would a person who directs somebody to do something, and that wouldn't be a lawful order, but rather a, hey, look at the shit that's happening, why would that not be a matter of explicit just helping out, aiding officers, as opposed to you are actively investigating and acting outside of the scope of your job?
Okay, I understand what you're asking, but I think this should be left for the expert witness.
Well,
I cannot attest to this.
I mean, is it your testimony, sir, that you don't know how to answer that?
It's that I was a chief legal counsel. I know how to answer it, but I'm not an expert witness in this case. I'm not sure if my word would hold up here, Your Honor.
Well, I just, in due respect to you, Mr. Meckley, you're a well-respected legal professional. I don't want you making objections on behalf of the party here, which is maybe a bit of. I appreciate what you're trying to do.
Yes, Your Honor.
I appreciate what you're trying to do, but let's let the parties discuss that issue and just try to answer the questions.
Okay, I can answer the question.
Okay.
There's a difference between a civilian saying, hey, that guy's committing a crime, and a law enforcement officer saying, stop there or you're going to be arrested. There is a difference, but civilian employees cannot give lawful orders. I cannot, Commissioner Dickman cannot, the deputy commissioners cannot give lawful orders. They can only give NYPD orders to other officers. They cannot tell a civilian to stop. Well, in the case of, if they tell someone to stop, they don't have to listen. It's not illegal for them to ignore them. Counsel?
Rossi.
Just looking at his notes.
Your Honor, what do I... I'm not sure what to do at this point.
Rossi. Oh my god.
I don't think
I'm back. What's up? Sorry, I had a map.
Okay, there. Okay, there.
Okay, alright.
Oh my god.
It happens. No worries.
Do I need to repeat my answer, counsel?
Well, yeah. Did you hear what he said? What?
Yes.
Oh no.
Oh, okay, you did.
Why is
hear?
it fucking lagging so
You did
much?
hear? Alright. Alright, then you can move on to your next question.
Okay. So when you dealt with this person, could you interpret the slang that was involved?
I could, yes.
And why was that?
I had just gotten off of another case where the exact same slang was used to sell methaqualudes.
Got you. Would you mind if I handed over a question, Your Honor, to the other, because I need to pull a casserole out of the oven right now.
Yes, absolutely. I would not want your casserole later. I would
Okay,
not
thank
want
you.
your casserole.
God bless you.
Okay. Mr. Hancock?
Okay, I would not say I'm necessarily
about to
prepared
starve,
for
by the way.
questioning right now, so I'd much prefer we wait for him to get back in like a minute, maybe.
Okay. Well, apparently Mr.
Have some
Meckley
food.
is going
Especially
to
with the-
starve, So, Mr.
Oh, hold
Meckley,
on, I can grab
you're-
him some food.
Okay, well, go grab some food. We'll have a brief recess.
Also, I wouldn't want to violate one horse, one rider by switching up questioning in the middle.
Well, if I give explicit
Probably the whole
permission,
issue,
it's
Anna.
different, you know?
Alright, thank
Okay,
you,
I'm back.
Mr. Hancock.
Okay. We just took a break while you were away and went to go
Got
grab
it.
some food. So you're welcome to come back up and resume your questioning.
Gotcha. Can I get a reiteration?
What?
What? Huh?
Never mind.
Huh?
So, when you mention Quaaludes and the fact that you know the slang, how long have you served in law enforcement?
At that point in time, I was 2 months as the legal counsel. This was after a year of chief public defender. Which,
Gotcha.
keep in
Which,
mind, as
keep
chief
in
public defender, I encountered similar terms as both defensive and government investigation.
So for 2 years, would you say that you've heard a lot of slang in terms of the narcotics which you were dealt, or which passed around you by ear?
Correct. I am aware of the vast majority of street slang. However, it is ever changing. So I may be uninformed of new ones. However, old ones I am very well informed with.
Okay. So when you hear quesadillas on the street in this specific context, what is the first thing that pops in your mind?
Methaqualudes. Or Q.
Okay.
Some
Or
people
Q.
just use the initial.
And why is that?
It is in an attempt to hide the illegal narcotics from law enforcement. However, most people do not understand that the street slangs are widely known and can still be used to question someone.
No further questions, Your Honor.
Sorry, in which case we're going to go ahead and invite the defense up for their cross-examination of this witness.
Hello, gentlemen.
Hello, Mr. Mech. How are you doing today?
Alive. That's all I can say, honestly.
Objection irrelevant.
That's good to hear.
We're,
That's what I was doing.
it's a little bit of levity, counsel. Overruled.
Do you object to that? Oh, I didn't even hear the objection.
It's okay. We all need a little bit of
Okay.
a laugh. It's been a long day, so.
Indeed.
Um, all right. So I was taken a little back by that, but Mr. Meckley, on May 22nd, you were operating as chief counsel for the New York Police Department, correct?
Correct.
All right. I know you described it earlier, but I want you to describe in detail the exact job description and authorities granted to you.
Sure thing. The exact job description I was told
Your Honor,
once being
narrative.
hired.
Objection.
What is the objection?
That's a lot of shit to talk about. It's a
Okay,
narrative.
let's-
He's asking him to describe a
and
whole
let's keep
litany
the
of stuff.
profanity
Let's keep the profanity
off the
Sorry,
record.
apologies, Your Honor.
off the record.
Yeah, well, okay, so the question was about his job duties. I don't think that's narrative. I think that's pretty specific, and the witness's answer is probably going to be pretty specific in response. If he goes on for a while about a bunch of things that are unrelated to that, you're welcome to re-raise your objection, but for now it's over.
Re-raise your objection. Counsel.
May I ask, additionally, relevance?
Establishing the background of a witness goes to credibility. This is pretty widely accepted throughout courts across the country. I'm not going to rock the boat by...
I'm not
Gotcha.
going to rock the boat by...
Okay, overruled. Continue.
May I proceed? All right. The job description given to me by the NYPD board is the following is entrusted to me. I was in charge of training individuals as to any legal capacity, be it paperwork or probable cause, as well as I was a non-sitting member of the board that reported to the board on any issues need to be resolved. My main job, however, was lawsuit prevention, keeping people from suing the NYPD based on what the officers do. My secondary job was to work with internal affairs to get rid of officers that are deemed a lawsuit hazard. The abilities entrusted into me was the ability to take out CCTV, as is per Captain Level. I was not a captain by uniform, however, I was considered to have the abilities to a captain or someone sitting on the board. Would you like me to continue?
No, that is sufficient. Um, I apologize. Somebody was calling me. Um,
Of course.
so you are not a police officer, correct?
Correct. I was not a law enforcement officer. I was not a uniformed officer and could not produce in any capacity any sort of lawful order.
And you weren't acting in any official investigatory or investigative capacity on 22nd, were you?
Correct. I was simply riding along with my friend Henry Collins.
Yes, you stated just hanging out in your affidavit. So this was a social outing.
Yes. Correct. It was originally a social outing before everything listed after happened, in which case I was simply a witness.
So you were not observing from a professional or law enforcement counsel perspective?
I was observing as... That is a confusing question, as I was always on duty at the time. However, because I was a salary worker, I was not allowed to be off duty. I had to be on call. However, if you are referring to if I gave them advice based on what to do, there was, I believe, one point where I informed them, just act once you believe you have reasonable suspicion. And then I believe the uniformed officers took it from there. That was the only bit of advice I gave them.
You have a close personal relationship with Henry Collins, correct?
Define personal.
You are close friends.
Correct. Henry Collins is a
I'm
good
gonna
friend of
object to
mine.
that based on relevance.
I mean, I think I know what the relevance is, but I'll let counsel for the defense give us some illumination.
So, yes, the relevance is to see if there is a bias or underlying motivation due to personal
Yeah.
friendship.
I
Or
no need to go
personal
further.
motives.
I agree. Overruled.
Very well.
So you have both a professional and personal interest in supporting Mr. Collins and the officers involved in this case.
What the hell just happened to me? I did not hear the past 30 seconds. Please repeat
Let's
whatever
keep
you
the
said.
profanity to a minimum, Mr. Meckley, but yeah, maybe you repeat your question.
Yes, Your Honor.
Yes. You mentioned you're close friends with Henry Collins. So you have a professional and also a personal interest in supporting Mr. Collins in this case.
I would have to disagree. I was an unbiased third party at that point. I was not attempting to help Mr. Collins with any case, considering I believe he understood since he witnessed the case he could not prosecute in any capacity regardless.
So you're stating that you have no personal connection and you do not intend to support him in any manner?
Oh,
Hello?
I
Your
believe
prosecutor's
Meckley might
down.
be having. Yeah, that. I believe the witness is having internet issues, and Rossi.
Okay, so apparently somebody's put a curse on our courtroom today. My mistake. I don't know which I ended up upsetting so far in the past that I would be cursed with unfortunate court circumstances, but here we are. Mr. Meckley, how's your internet situation? Okay, you're...
I'm alive.
Oh, he's back.
Okay. Mr. Sorry, and I have to remind myself your name, Mr. Hancock, so I don't get
Marcelo,
confused with your cousin. Mr. Hancock, are you fit to do objections in Mr. Rossi's absence until such time as he returns?
Yes.
Okay. In which case, you can proceed with your questioning.
So, you are stating that you have no personal interest in supporting Mr. Collins in this case.
While I have no personal interest in this specific case, I do have personal interest in Mr. Collins as he is my friend. However, in this explicit capacity, no, I do not have any personal grudge against the client or any personal belief to uphold the case, aside from the fact that a law was broken and justice has to be served.
Where did you pick up officers from with Mr. Collins specifically, the location?
I believe it was around the car dealer area. I could be wrong, as this was several weeks ago at this point. However, to the best of my knowledge, it was around either the car dealer area or just like slightly past it, maybe near the Brown and Son scrapyard.
And immediately after that, picking the officers up, where did you go?
I believe they went towards the bank side in order to return back to the police department. However, Mr. Collins took a right because he wanted to, and I quote, take the scenic route instead of going left, which would be relatively quicker. In which then, as stated before, they overheard, everyone in the vehicle overheard your client talking about a deal, prompting to Mr. Collins to follow.
So, to clarify, the bank, where is the bank located?
Oh, I'm sorry. It's the Little Israel Deli now, which is directly, I want to say, down the street from the scrapyard. Or is it
Your
the
Honor, if I
scrapyard, Brown and
may,
Sons?
it would be a lot easier for location-wise if we just give the court the public database that is the Department of Planning map, which would show very clearly where each location is.
No, there's no objection using it as an aid to. Can it
I'll
be
put it in the
submitted in the ticket?
And
Let me
as
open
a
this up.
note for the court, what is otherwise known as the Jewish Deli is Apartments 5 on the map.
Take your time, Your Honor.
Whoa, is it just me, or is Rossi's voice a bit deeper now?
He looks a little different.
All right. So earlier you mentioned bank, but now you're saying apartment 5? Why did you say bank earlier?
The area was once known as the bank area because there used to be a bank there. I believe there is a ruling where if you refer to a place as a commonly known name, it can still be considered that place, such as the boathouse, or a different location where it is officially not called the boathouse.
Well, that
Regardless,
second part
I called
wasn't
it the
my
bank
question,
because
but I
it was known as the
understand what you're-
bank for the longest time.
And looking at that, you mentioned earlier that they were taking the scenic route. It seems like that's really out of the way from heading to the police station. And it seems you also have to drive past the apartment 5, even if taking the scenic route. Why did you stop why was the car stopped at apartment 5?
I cannot attest to this. I was not the driver. I don't know why he stopped originally, aside from overhearing the conversation.
But you didn't directly hear the conversation.
No, I overheard them talking about a deal as well. Everyone in the vehicle, I believe, overheard the conversation.
So what
The
did you...
defendant was on the phone.
Okay, and what did they specifically say?
Are we going to get this deal done? Was, I believe, more or less their words.
And they weren't talking about math?
Math? Meth or math?
Yep.
I'm a little confused.
I said math, M-A-T-H.
They could have been. I was in the passenger seat. I was relatively farther than Collins was to the individual, so I cannot say at this point.
But you don't know what they said.
I understand most of what they said. However, if you're asking if I heard the entire conversation, it's a no.
Well, this answer is not being asked. You don't know specifically what they said.
Objection,
or you
badgering.
don't remember. I'm asking for clarity. It seems pretty important.
Also asked and answered. He already answered it. He's just asking the same thing again.
Yeah, I'm rather confused.
Do you need me to repeat the question?
Yes, please.
Okay. So, you do not definitively remember what was said exactly.
I remember the vague gist of it. However, it has been 3 weeks since the arrest, so it is a little hard to remember the minutest of details.
It seems like this is a pretty relevant detail, would you not agree?
I would have to disagree. I was not the one that made the choice of following them, and I was not the one that arrested them. I was simply a passenger and a witness.
So, to have interest in the conversation, as you put it, would it be an interest in their arrest? In your opinion?
You would have to ask one of the officers. That is not my choice to make. I don't know if it would or wouldn't.
Well, you just said that it's not relevant because you wouldn't arrest them off of it. So, you're saying
I did not
that
say it
if
was
you
not
were-
relevant. I said I do not know.
Okay. You claim that Mr. Collins followed the black gentleman in your affidavit. You say that after hearing
Correct.
him say, "Let me do math on this." Is that correct?
This affidavit was written 3 weeks ago. If it's what it said, then yes, that is what happened. However, I myself cannot recall at this current moment, as it has been, once again, 3 weeks since the arrest.
Okay, so did you earlier, when you stated earlier that they were doing a deal, or you heard them talking about a deal, were you lying earlier
That
or were you
part I
lying in your
clearly-
affidavit?
Neither.
Well, are you aware
I'm
that your
going to
affidavit
renew my
contradicts what
objection
you
for
just said?
badgering.
And I'm gonna sustain this one. The witness has clearly indicated that he doesn't clearly remember. This is an improper impeachment.
All right.
Any other questions?
However, yes, I do. So you're suggesting that the phrases they used at that time were indicative of drug activity?
Correct. It is common use among drug activity, especially the mentioning of quesadillas and the patting people down. Those are all actions that are done during drug activities.
Well, that was not my question. I said what you heard at that time at the Jewish apartments. That was indicative of drug activity. Is that true?
I believe so. Like I said, I did not make the choice to follow them. I was a passenger, and I am still having trouble fully remembering that situation due to it being a rather small part in the rest of the arrest.
And to clarify, they didn't mention quesadillas at that point in time.
Yes. At that point in time, they only mentioned, I believe, about a deal, and I believe about math. I cannot remember fully. You would have to ask another witness.
So, isn't it true that the phrase doing math, standing alone, is vague and can relate to anything from shopping to checking prices?
Correct. It is a good thing that a law enforcement officer didn't act on this, and instead, a civilian on his own accord followed them.
That wasn't my question, but you did answer.
Hold
in the
on, I'd
beginning.
like him to re-ask the question. I do have a potential objection to that.
Too little, too late, Counselor. The question's no longer pending. Continue.
So, no crimes were witnessed at the apartments.
Correct. As no arrest was either made as well. At that time.
And you witnessed the defendant go into the apartment and then come back out of the apartment and get in their vehicle, correct?
I did not witness them go to the apartment. I don't think I stated that on my affidavit either. I'm unsure where you are hearing this from. I believe he was coming from the apartment, but I don't believe he walked to his car, to the apartment, to his car again.
So you're unsure of what you saw.
If I'm to reiterate, this part of what happened was something I was not fully paying attention to because I was already busy with other works. I only started paying attention once they pulled to the casino. Like I stated before, it has been 3 weeks. The minute details of this specific section are a little lost on me.
And at that point, you didn't see any drugs, any money, or any weapons, correct?
Correct.
And you said Mr. Collins followed the man of his own accord.
Correct.
And I'm quoting from your affidavit. So there was no tip, no warrant,
No
and
tip.
no call for service.
No warrant. Correct. It was a civilian acting on his own accord because he was curious, which I don't believe is illegal.
And
Move him over
how
there.
long did you follow the, did Collins follow the driver?
It was roughly a minute or two before the driver pulled into the casino, in which case we parked near them as well.
And no traffic infractions were witnessed in this time?
Not to my
Objection,
knowledge.
Counsel, what are we asking about the traffic stuff for?
Which
I misheard.
Sorry, for the defense.
So-
What are we asking about the traffic stuff for?
What are we
Gotcha.
asking about the traffic?
Why? Because it establishes if there was a crime or an infraction committed on the way, which would lead to potential reasonable suspicion and authorization to stop. But in this case, there was no traffic
I've sort of
infraction.
said
Also,
this
lack
already.
of foundation. There was no stop testified to.
Well, and the
It
other,
was-
the real issue here is that, as I've said, we're not litigating whether or not there was, probable cause or reasonable suspicion for the stop. That would have had to have been taken care of a whole lot earlier. We're here on the evidence that's in the case and whether or not the defendant meets the elements of the offenses charged. So we're not going to ask questions about probable cause. That ship has sailed. So the objection is sustained. I ask that you move on.
Okay, and you said another. All right, I apologize.
Take your time.
So you said you saw another individual walk up to the car once it was parked?
Correct. This individual is in police custody. His full name, I know his last name is Angelo. I can check what his full name is if required.
Bobby Angelo.
Thank you, ADA. That is the correct person that is currently in police custody.
Can you describe what that individual looked like?
Objection relevance.
This is about what the witness saw on the scene on the day of the alleged crime. This is completely relevant. I mean,
Alright.
we're getting to like the core of
getting to,
identifying people who are potentially involved. That's the mirror image of relevance.
I believe it was an Italian male wearing a brown jacket.
Moment, Your Honor. How did you know he was Italian?
Because his identification card said Italian. His driver's license said his nationality was Italian.
So you viewed his ID and driver's license?
No, an officer showed it to me though. As at that point I was operating as the chief counsel once he went to the cells.
Okay, so to clarify, an officer showed you his ID in the cells.
An officer had me check the ID in the cells, yes, as I was assisting with the processing of him at that point.
And can you describe processing? What is, you're assisting in the arrest?
No. The processing
Okay,
is
objection
from...
relevance. This is not about the arrest of Bobby Angelo. We've established the man at the scene. The processing of Mr. Angelo has no relevance to this case.
Is there a reason?
Correct.
Is there a fact of consequence that we're getting to here, counsel? For the
Yes,
defense?
witness stated earlier that they were not involved in the arrest or the procedures, that they were simply there to view, and now we're hearing otherwise. I believe it's pretty relevant, even though this other individual is a separate individual in a separate case. It still involves in the same event that took place, so it still sees if this witness was involved in the process of the event.
Okay, I'll allow this line of questioning only to the extent that it challenges the credibility of the witness by attacking prior statements made to this court. But,
Okay.
talking about the specifics of the other case, unless there's some reason that you're tying it here, some fact of consequence that you think is important other than just, giving some context, we're not gonna go further into that.
To give context, when you referred to if I assisted with the arrest, no. I did not yell any lawful orders. I did not have cuffs at the time because I am not a law enforcement officer when I was chief counsel. When I'm referring to processing, I'm referring to simply having what charges are being applied to them properly written up on paperwork. That was one of my duties, is assist officers with the writing of plea deals, criminal complaints, and what charges have you. Officers needed help figuring out how many counts of narcotics this would be. I assisted. The identification, the reason why he handed me the identification is I needed his SSN and his full name to put on the criminal complaint. Because of that, I also saw his nationality was Italian. Does that explain everything to you?
Yes. So you never personally went into the pockets of any of
No.
These individuals.
No, that is not my job. That's a law enforcement officer's job.
What is the point of asking, objection relevance, what is the point of asking if he went into the pockets of these certain individuals?
Sorry, I just realized I had said that off the record. He's testifying, or he's asking the witness to testify about, sorry, hold on, I have to reorient. This is testing the previous line of questioning from the witness, where the witness testified that he was not involved with the arrest in some way. Counsel's just exploring that.
But where would the pockets be involved?
Maybe
Well, that's maybe part of the arrest procedure, as I understand it, that you search a person's pockets, that you conduct that. And so if he had done that himself, that would lend more credence to what counsel is saying and cut against the credibility of the witness. So I will say, if this is going on a while, we're getting to the point where maybe this is being more repetitive and less probative. So let's, find
I'll
the point
cut it up.
here.
It was yeah, it was relevant to later on seeing if we can impeach the witness. However, yes, I'll speed it up.
Your Honor, he
And,
just mentioned impeaching the witness. Is that a motion?
I think, and counsel, you can correct me if you're wrong, I think he's referring to informally impeachment as a means of attacking credibility rather than motioning to, have the witness's testimony stricken or, with some kind of perjury charge, just attacking the credibility. Am I correct, counsel for the defense?
Yes, so
Okay.
yes, impeaching is just challenging the credibility. In the case, I would have said motion, move, or
Okay.
strike him if I meant otherwise.
Okay. Continue.
And you mentioned earlier in your testimony that you heard the word quesadillas being mentioned.
Correct, in front of the casino.
All right. However, you're not a
may I-
narcotics officer. Correct?
Yeah, correct. I
Still
was chief counsel.
badgering. I objection once again renewing.
Overruled.
So
Also,
you're...
Can I interject just real quick? District Attorney Henry Collins has informed me he's only going to be available for a little longer, so I don't know what you want to do with that information, but it may be possible the witness might have to leave if this continues with just me.
Okay. Objections from the parties to temporarily excusing Mr. Meckley so that we can call Henry Collins, and then we can take care of his testimony because he's going to be the unavailable or the difficult to get a hold of witness, and then we can call Mr. Meckley up to finish any questioning that needs to be performed. Any objections to that?
I have no objection to that.
I object. It's my birthday. I don't want Henry Collins up there.
Thank you.
Happy birthday,
From the
Commissioner.
defense.
Okay, I mean, I don't like that we are doing this. I understand. We will have a chance to continue again, just to be clear, correct?
Yes.
We're not done
But
with the.
I
all right.
understand if you don't want to do that, but the consequence of that is that your defendant is going to be waiting for Mr. Collins to come back, or for the next available date with Mr. Collins to be here, which is essentially
Yes.
through the middle of next week.
Yes. We'll have Mr. Collins come up.
Okay.
That is fine.
All right. Mr. Meckley, for now
Okay.
you're
Do you want me to switch positions with him?
Yes, please. And then you'll be recalled.
Okay.
Who
While
let a
that's
bird in
happening,
here?
I'm gonna take a quick leak, and I
My
swear
pet
it's
bird.
gonna be like 20 seconds. So.
I feel like it should have been like at least a minute. You know, washing your hands takes a minute, at least.
Hey, Rossi, this pigeon gonna
Gilliman,
take
Your
your
Honor.
place.
I don't know.
Oh, my back!
Wait, does the pigeon have body groups?
The picture?
No.
What the? What, did you have an
left like
accident
that.
back there and break your legs?
I was standing there for so long my legs gave out.
It's because they refused to accept this motion to extend his legs, his leg length. I think he needs a booster seat. He's a little small.
He doesn't. Let's not, like, elongate this any further than we have to.
That's what she said.
Hey,
Is this thing on? Hello?
Yes, it is. I believe he's still taking a leak.
If he doesn't return in 5 minutes, I'm gonna fucking blow my head off in front of the
All right,
courts.
gentlemen. We're gonna go ahead and swear you guys.
You want to take a
Swear this
five?
with-
Can you take a 5-minute recess, Judge?
no, what?
For no reason. For no reason.
Why?
All right, I'm
For
gonna
no
swear the
reason,
witness in.
fuck off.
Let's come on, guys. We got a testimony to get through still. All right, I'm gonna swear in the witness here. Mr. Collins, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God, under the pains and penalties of perjury?
Under the Almighty God, I do swear to speak the truth, the full truth, and nothing but the truth, so help me God under pain of perjury.
So sworn. Counsel for the prosecution, please be in your direct examination.
I believe Mr. Rossi has asked me to take over for this stage as his connection issues continue to plague him.
I think there's a shootout outside.
Well, unless
Yeah, I'm
they're
gonna wait
shooting
till
up
that
this
concludes.
court, we're fine.
Okay. Good evening. Please introduce yourself for us.
My name is Henry Collins. I'm the district attorney for the county of New York City, New York State.
How long have you served as district attorney?
I'd say a couple of months now. I don't have an exact number because I don't like to keep track.
And how long have you worked with the district attorney's office?
Close to, I'd say about, maybe 7 months, maybe.
How did you come to be involved in today's case?
Well, I was, giving officers a ride after their car had broken down. They had Joe Meckley with them. I was, giving them a ride back. But, a man was talking about math, so I, decided to follow him out of my own curiosity.
Would you please name these officers?
Yes, Micah Devon, Jetty Jakowski, and Mason Peralta.
Mm-hmm. And you mentioned a man mentioning something about math. Would you please elaborate on that?
Yeah, the black gentleman standing right over there was talking about math, so I took a short detour to follow him in a civilian manner.
Can you please properly identify that quote-unquote black gentleman for the court?
Yes, that gentleman right there.
And what is his name?
His name is Shinko Doe.
Thank you. Give me just a moment.
We'd like to make a note of the word black gentleman being used in this instance, Your Honor.
Cross-examine on it. Let's move on.
All right, give me just a moment. I lost my train of thought there.
Jesus Christ.
Now, where was this man yelling about quote-unquote math?
He was talking about math at the Jewish deli / the Jewish apartment / Little Israel.
And from there, what happened next?
Well, I, out of my own volition and curiosity, drove my car following him to the casino, where he proceeded to walk up to my car and ask if I was the gentleman on the phone he was talking to about the math. Well, not in that matter. He was just more so asking me if I was the gentleman on the phone.
And how did you respond to him?
I didn't respond at all. I sat there silently in the car.
And where did he go next?
He proceeded to walk back over to his car, where another gentleman by the name of, I believe it's Bobby Angelo, walked up. He proceeded to pat him down for wires. Just think.
Would you
Sorry,
please
it's been a minute
clarify
since-
who he was who patted down for wires? Was it Mr. Angelo or Mr. Shinko?
Mr. Doe patted down Mr. Angelo.
Please continue.
So, he had asked them if he was looking. No, sorry. He was asking for quesadillas. He was like, "You asking for quesadillas?" Question mark. And then he proceeded to pat him down. Now, at the time, I did not know that quesadilla is a known slang word, but I don't really want to talk about it because that's not my place. But after that, he patted him down. The officers proceeded to get out of the car once they got into the trunk, and they began to initiate a detonation to talk to the gentleman. That is when Mr. Doe proceeded to try to hightail it out of there when one of the officers swiftly tased him.
Very well, just a moment. To your knowledge, once both Mr. Doe and Mr. Angelo were detained, what was found on them?
To my knowledge, the officers informed me that I believe there was 1 jar of methaqualone on Mr. Doe and 4 bricks of cocaine in the trunk.
Very well. Just a moment. My main counsel rather, has once again departed from the city, so I'm just going to double check with him.
Okay.
And just to double check, who is the owner of the vehicle where the cocaine was found?
The owner of the vehicle, to my knowledge from the officers, was Mr. Doe.
That is all for direct examination, Your Honor.
Okay. Counsel for the defense, you can proceed with your cross.
Hello, Mr. Collins. How are you doing today?
Terrible. It's been an hour and 30 minutes of sitting in an empty room. My legs gave out on me.
Yeah, I do apologize for the long wait. However, we'll get to the questioning. Um, can you state, or I apologize, let me re-ask this. So on May 22nd, you were driving your personal vehicle with Chief Counsel Joe Meckley, correct?
I was driving my car around. I had picked them up and stuff at the car dealership. Their car had broken down. Mr. Meckley, I believe, was with the officers at the time.
Okay, so you picked up Miss Meckley with the officers at the dealership.
I believe so, yes. It's been quite a while since the date.
So he was not in your car beforehand, just to be clear, you were driving solo beforehand.
I had just picked it up from the car dealership. I could not tell you honestly if he was with me or if he was with the officers. It's been quite a long time.
And you were giving the officers a ride back to the NYPD, correct?
Correct.
All right. Just to lay some foundation, I had forgot to do so. What is your job description? You said you were the DA. Can you list your powers and authorities as the DA?
Yeah, sure. As the district attorney, I am authorized to
Objection
grant...
relevance to this question. The witness did not act in his professional capacity as district attorney during this incident.
Yeah, I'm inclined to agree. I mean, if there's a reason for this question, I'll allow it, but, you know, we're getting a little bit of field of just the background and credibility here. I don't know.
Yeah, so in terms of seeing if there's any underlying powers or authorities that are granted to him that are not known or can be drawn from another source, we're clarifying the capacity in which he can work in as a government official, because there's no off-duty, on-duty for the district attorney.
Let's
So
just keep the line of questioning brief, but I'll allow this question.
So, as I was saying, I am granted the authorization to give immunity to people in return for testimony. I am able to prosecute cases. I am able to conduct investigations of sorts. I am able to interrogate witnesses if needed to get a better understanding of the situation. I am able to go onto crime scenes, document stuff with photographic evidence, such as a camera, take pictures of stuff for the record and stuff. I am able to just look around a crime scene, see what's going on. Just basic investigatory stuff for active crimes. Other than that, I can authorize plea deals on a lower amount than officers can. And yeah, I believe that should be just about it. I don't know.
is there any documents that state the scope of these powers?
I believe there is, however, the document does not list the full power that we have, as the power has in fact grown since the last amendment to it. There have been clarifications by the governor, the attorney general, and the Senate over time on what we are and aren't allowed to do.
So in terms
From what I
of
understand,
continue.
From what I understand, there is a brief description of the most minor of powers that I am authorized to do. However, there is definitely a list of things that aren't on there that we are authorized to do.
All right. Okay, so you were driving police officers to the NYPD. However, you said you were by the car dealership, um, and you ended up at the Jewish deli, correct?
Correct.
Jewish deli is out of the way of the direction of the NYPD, correct?
Incorrect.
So
There
you
are
said you
multiple
have to
routes in which
pass
you can
by.
go there. So the multiple
I'm
routes you
talking
can go
about
from
the
there.
most direct route to the NYPD.
I don't usually follow the most direct route. I just kind of follow what my soul lets me to do. Sometimes if I'm coming from car dealership, I'll pass Brown and sometimes I'll take a left, go through Little Italy. Sometimes I'll take a right, go through the deli's alleyway, or sometimes I'll even really just take a right at the car dealership and go the far way and take the long ass road down. Pardon my language. The long road all the way to the PD.
Okay, so was there a reason that you decided to, so looking at a map, just really quick to establish, would you agree that from the car dealership, the quickest route is take a look?
Apologies to interrupt, but I don't believe this witness has been handed the map for the Department of Planning.
I believe it's accessible.
He should be given a moment to pull it up.
Sure. Take a minute and pull up the Department of Planning map if you think that's necessary to assist you.
I have it.
Okay.
I have it now.
Okay.
Resume the question.
So would you agree that the quickest route from the car dealership is taking the immediate left, going north, and then east to the police station?
I mean, not really. In my opinion, the quickest route would probably be going past the drugstore and going up through Little Italy. You go a more direct path, but there's more turns. However, in my experience, it seems usually most quicker.
Okay. However, you didn't take a left at the drugstore, you took a right. Why did you take a right?
I just felt like it. I mean, there's not really much there to explain. I just don't really ever plan out how I drive.
And you stopped at the apartment 5 or the Jewish deli. Why did you stop?
Well, I overheard him talking about math, so I was listening for my own curiosity. The officers in
So
the car
you
didn't seem to
overheard
complain
him?
when I stopped.
So you overheard him while driving past? Or were you in the parking when you overheard him?
Let me think about that, because it's been a minute. I have to actually see if I can thoroughly remember that. My memory is a bit fuzzy, but I want to say that I may have been driving past. I don't remember if it was me going through the alleyway or if I was just driving past.
So you weren't sitting there listening, you overheard them as you were driving past.
Either that or I had been pulling through the alleyway.
One of the two, but there you don't remember directly.
No, my memory's very fuzzy. I suffer from a medical condition called attention deficit disorder. Actually, to be more specific,
so-
attention deficit hyperactivity disorder.
You don't remember exactly what the defendant said then.
The only thing I can remember clearly, it was somewhere along the lines of him talking about math and piqued my curiosity.
However, is it true that there could be a possibility that you're mistaken from your attention hyper deficit
There is a
attention disorder?
possibility, however, I highly doubt it. The math part generally stuck out to me. Unlike which way I was going. I mean, the way I drive is completely random each time. As I said, I don't plan out how I drive, but sometimes I'm able to remember words a little bit more interesting, such as when somebody's talking about math. When I was a young child, math was one of my favorite subjects.
The
Okay, but he didn't say
prosecution would like
anything-
to strike that last sentence based on relevance. His childhood affinity for math is not relevant.
Sure, yeah, that's fine. We can strike that. So stricken.
So, there was nothing incriminating in which he said.
No, that's why I followed him in a civilian manner. If I were to do it in a official capacity, I would actually drive the officers back to the NYPD and have them get their vehicle and investigate it themselves further.
Okay, so because a black man said math, you decided to follow him.
Correct.
Any motives as to why you followed him?
No, just like my
Specifically-
driving standards, it's usually just random. If somebody says something interesting, I'll usually just follow them around, see what they're doing for a little bit.
Was it because the individual was black you followed him?
Objection.
No, I actually,
Argumentative / badgering.
I mean, beyond that
Overruled. This is
point, I
testing
mean,
the
I have
credibility of
no
Also
affinity.
improper impeachment.
Again,
I have no
overruled.
affinity
This is
for a
testing the
person's
credibility
skin
of the
color.
witness.
Very well.
I have no affinity for a specific skin color. I like black people, I like white people, I like Asians. I really don't care. I have had sexual interests in Asian women. I've had a romantic relationship with a very nice
Okay,
black
I mean,
woman
within the scope,
and white women.
but I understand. Okay. So, earlier you addressed the defendant as that black man. Is that correct?
Correct. It's the easiest way to point it out, as it points out the difference between the white gentleman that we arrested and the other black gentleman, which is Mr. Doe.
But in your affidavit, isn't it true that you address the defendant here as that black man, and you address the other individual by his name?
Yes, that affidavit was formatted for the Bobby Angelo trial, so I did not find it relevant to put that name inside of the affidavit. Unfortunately, we did not have time to redo the affidavit for this trial.
So this is the incorrect affidavit for this trial, then.
That is not true. It is an affidavit that is the exact same event. The events are just across two different defendants being prosecuted separately. The events are no different. Both of them were involved in the end. And at the end of the day, he is just called that black guy because I had initially planned on writing a second affidavit for the Doe trial, but never got the chance because I was very busy.
So when you pulled up to the casino after you left the apartment, where were you parked?
I was parked. I want to say. Let me think about this one. So, at the casino, there is the front door, and in front of it, there are a couple parking spots. And to the left of those parking spots, there is a bush, and then more parking spots. I was on the right side of the bush, and the gentleman, Mr. Doe, was on the left side of the bush.
to be clear, were you in the parking spots facing the casino or in the parking spots to the dock?
There aren't no parking spots that face the casino. It is illegal to
I
park
apologize.
anywhere
That
except
is a-
for
that is
facing
a,
towards the docks.
Okay, so facing towards the docks then, you were on the right-hand side.
Yes.
How many parking spots away from you was the defendant parked?
He was parked directly next to me. The only thing separating us was a small bush.
And you overheard the conversation that they or I apologize. And another individual walked up to the car, correct? Defendant's car.
Before that, the Mr. Doe, the defendant, walked up to my car and had asked me if I was the person he was speaking to on the phone. Yes, after that, another person, a white individual later identified as Bobby Angelo, walked up to him.
Can you describe what that individual looked like?
Yes, Mr. Bobby Angelo was wearing a gray flat cap, some shades, a brown jacket with a white shirt, and some black pants.
Okay, to be clear, you say a gray flat cap, brown jacket, and white pants?
Black pants.
And the individual entered the vehicle, correct? The defendant's vehicle.
Yes, he entered the vehicle after being asked about quesadillas and being patted down. He then proceeded to open up the trunk and place some items in
Well,
there.
we're
from
not
what I
there yet.
understand.
I'll ask. But I appreciate your enthusiasm. So you heard them mention the word quesadillas. Can you tell me exactly what they said?
Give me a minute. I believe he was, Mr. Doe said, "You asking for quesadillas?" in a questioning manner.
So it was the defendant that was asking about the quesadillas, not Bobby Angelo.
Correct. It was more so that Mr. Doe was asking if Mr. Angelo was interested in quesadillas.
Your mic was kind of spazzy there. Can you re-say that?
Mr. Doe seemed to be asking Mr. Angelo about whether or not he was interested in quesadillas.
Okay. And would you agree that quesadillas mean a variety of things, such as food items,
Objection.
tortillas with
Outside of the
cheese?
scope of the witness, he's not an expert witness in terms of its relation to drug paraphernalia. And that is
This is
the
asking his
relation that is being
opinion.
insinuated.
Well,
I mean, if you would like me to speculate, I mean, quesadillas could be a
The
Hold
objection
variety
hasn't
of
been
things.
answered, Mr. Collins. Please hold up.
yeah. So, okay, I'll hear from defense on I guess why they think their question is fine. We'll go from there.
Yeah, so this is based off an assumption. We're trying to understand the witness's opinion of this assumption, and establish that there's a variety of alternate meanings, and to see what the scope of this word means to the witness. We don't actually understand at this moment how the witness interprets this word. They testified partly to it earlier in the direct, however, we're exploring that now in the cross.
Okay. Well, during the direct, we heard that the witness interpreted in this setting to mean that there was, I believe, somebody mentioned the exact word. It's quaaludes is the common name.
Methaqualone for the
Actually,
legal name.
this
Yeah.
witness said that he does not know what quesadillas means earlier.
That
You can check the record, but he said
that's
that.
not.
I'll review the record. I guess maybe I'm misremembering that, but
I mean, to answer the question,
well,
I can answer it.
hold on. Well, we're just trying to sort out the objection here. So, I guess, can you just remind me of what the exact pending question was? Exact words.
The exact word was if the word quesadilla has many. Does he agree if quesadilla has many meanings to it?
Okay.
Essentially, and I gave an example.
Yeah, this question is fine. Overruled. Let's just not try to make him a language expert here. And I understand that Meckley has 8 minutes. This sort of is what it is. We're probably gonna have to go to a day 2 anyway, so let's just get the one.
Yes, I understand. I'm just alerting to you as he's updating to me.
Okay. Honestly, this
So-
isn't gonna be done in the next 8 minutes. Tell him he's excused until we pull him back for another day.
May I answer?
Yeah, continue.
So again, the question was if the word quesadilla.
I know what the question is. So the word quesadilla at the time that I witnessed the event, to me it was just a food item. However, afterwards the officers informed me that it was a.
That's not my question. I
You're
asked
asking me
if you
the
agree.
different ways it could be interpreted.
No, I asked if you agree that it could be interpreted as a food item.
I mean, in a way, yes. Sure.
It's a yes or no question. So is that a yes?
Yes.
And you heard, or one moment. And at no point in time was the word drugs or paraphernalia used when they were addressing each other. Quaaludes.
No.
And you heard this from inside of your car?
As stated before and on my affidavit, my window was rolled down.
Your window was rolled down. Was their window rolled down?
No, but my window, it's pretty easy to hear. It's a very small car. I drive a Mini Cooper. They are almost
heard them.
kissing my neck when they sit behind me.
So you heard them on the inside of their car with their windows rolled up.
There isn't an official objection for this, but I would like to object on the basis that this is arguing game mechanics for
to
the
clarify that,
voice
this
object in
conversation
Gmod.
happened. This, to clarify, this all that they were talking about happened before they even got into the car.
Yeah, and I think that this is.
Oh, well, that answers that.
Yeah, I was gonna say. I think
Well, earlier you said that they were inside the car.
That was for the second part, before the detonation. As
Okay,
stated in my
maybe I'm
affidavit,
mistaken
they
of
talk
how...
about it, and then they get
Yeah.
in the car.
Okay. So then you heard them mentioning, and you specifically said that the defendant was asking about quesadillas. You heard that, and then they hopped into the vehicle.
Correct.
Okay. So at that point, you and the officers were watching them.
Yes.
For how long did you watch them?
I'd say less than a minute.
And during this time, did you see any transference of drugs? Any drugs in the vehicle? Any movement of hands?
I did not see anything directly. However, they did open up the trunk.
So they were in the vehicle.
I am also
and they
going to
opened up
say
the
it's
trunk.
another game mechanic issue on transferring items to a trunk. Realistically, in character, he would
What I'm gonna say
be
is
seeing
that,
any transference.
What I'm gonna say is that I understand.
It's another game mechanic.
I understand how these mechanics work, so I'm gonna take the answer for what it is, with the understanding that I know how the mechanics work. Okay.
Okay.
So I'll give that the weight.
The
that
only
is
thing I saw was them open the trunk.
Okay. And at that point in time, the officers exited the vehicle.
Yes, after they opened up the trunk, the officers hopped out of the car and proceeded to instruct Mr. Doe and Mr. Angelo to step out of the vehicle.
Okay. And why did the officers get out of the vehicle?
I heard some faint whispers behind me. They were talking about how they had reasonable suspicion to detain them and the such, but I wasn't really paying attention. I was more fixated on the car itself.
And and were the officers following the orders of Mr. Joe Meckley?
I wouldn't say that they were following orders from Mr. Joe Meckley. Mr. Joe Meckley was advising them the best time to leave. If my memory serves me correctly.
Advised them to leave the car and seize the defendant's vehicle.
Yes, that is his job. He was at the time the chief counsel of the NYPD, which the entire job is to advise officers on the best way to conduct arrests, how to properly do the arrests to make sure that everything is legal in a matter when reasonable suspicion is established or when probable cause is established. That's kind of the whole point of what the job was before he eventually got offered a position as chief of staff.
So the officers then listened to his advice and executed at the time that he advised?
Yes.
Oh my goodness, someone's dying outside.
New York classic.
Okay. And officers, you mentioned, ordered the individuals out of the vehicle.
Correct.
But they did not identify that they were officers.
They were in their full uniforms, and I believe one of them did at one shout that they were police.
But you're not sure.
Let me think back on it real quick.
Objection argumentative. He did just say he believes so.
I have to
That
clarify
question's fine.
if it's a certainty or...
Yes, I believe one of them did say, had mentioned that they were police.
Well, question's not technically answered with certainty, but note that believed to be so. But to clarify, you're not 100%.
Correct. It was a very, very messy situation. About 3 officers were yelling over each other, so it was very hard to discern who was saying what.
So multiple officers were giving orders then,
Correct.
and it was confusing.
Not really. The biggest thing
I'm going
is
to
that they
object to the relevance here. There is no charge on the criminal complaint for disobeying a lawful order. The orders given are not of pertinence to the verdict.
Yeah, what is the issue? What is the fact of consequences this goes to?
So we're discussing here, he mentioned that he wasn't sure that there was a lot of officers shouting. If that is the case for the witness, then one of the charges is evading arrest, which we have pled not guilty to. We're establishing foundation here that if it was confusing and that there was multiple officers saying different things, that it was a misinterpretation from the officers on the defendant, which we'll plan to bring forward with testimony of the officer itself, as well as this and the other witness.
All right, yeah, that's relevant. Overruled.
So, as I was saying, they were mostly screaming, "Get out of the car, get out of the car, get out of the car," and that is when Mr. Doe proceeded to run from his vehicle, attempting to run towards the ATM at the right next to the casino, at which point a officer, I cannot remember the name of, swiftly landed a singular taser shot on him, subduing him and handcuffing.
So he was running to the ATM.
In that direction. He didn't make it past the asphalt. He only stayed on the asphalt.
And officers, you mentioned they tased him. Did he present a threat? Any weapon?
No,
I'm
however,
gonna once again
standard
object on
operating
OSC
procedure.
grounds. UA has ruled that the questioning of the use of a taser's generally considered iffy, thanks to it being the only way to physically restrain someone that is running. You can't tackle someone.
That's what also I was about to respond. The standard operating procedure allows them to use tasers to subdue individuals that are fleeing or evading.
There's no abuse of force claim here. This is not a civil case for that. It's not probative.
Oh, really? The standard operating procedure that I just read the other day says that there is a levels of force to be used. And,
As proved in the appellate
I
case,
wanna be
People v.
clear.
Schmidt, the
Hold on.
NYPD SOP is
Hold
not
on,
legal
hold on.
ground.
I want to be clear. It's not probative for today's case. There's no relevance for it. Move on.
Okay. And so you said that they tased him, and did the officers search the vehicle, correct?
Yes, one of the officers searched the vehicle.
And did they get consent to the vehicle?
At that point, they had probable cause, I believe. I do not know their thinking process. I am not the officer themselves. As I said, I was just a civilian bystander involved in it.
But at this point, no searches has been done. The defendant was, or to clarify, okay, so the defendant was tased and he was put in cuffs, correct?
Correct.
So he was under arrest at that point.
Yes, to my knowledge, I believe he was being placed under arrest for evading detention.
You said for evading.
Yes, evading the detention, which is a misdemeanor crime. If
Okay.
you would like, I could list off the penal code.
Nope, that's okay. And the and then did the officers didn't Mirandarize him at this point, correct?
Objection, relevance. The defendant's Mirandization has no effect on the verdict unless we are using his own words against him.
Yeah, what is the relevance?
It's to establish a timeline of what happened, because again we're hearing from multiple witnesses and we're making sure stories line up and are consistent with each other, and when, as of what happened and when it happened, stories are different. That's an issue.
Okay. Yeah, let's keep this brief, though.
Well, it's kind of unclear for me as I wasn't really focusing on Mr. Doe. I was more so focusing on Mr. Angelo, who had remained in the car, refusing Mr. Peralta's orders to get out of the vehicle. When he did finally get out of the vehicle, when Mr. Peralta walked away and proceeded to start walking away himself backwards towards the casino.
Okay. So, you said the other suspect exited the vehicle but walked away?
Yes, Mr. Bobby Angelo,
And-
after Mr. Peralta had looked away for a second to try to help out with Mr. Doe, proceeded to walk away backwards, at which point I asked for him to
So,
stop
hold on.
very loudly, and
Wait a
then
second.
at that
So, Mr.
point,
I'm
Peralta,
going
Mr.
to
to
once again
clarify-
object on relevance. The actions of Mr. Angelo aren't the most pertinent to the verdict based on Mr. Doe.
That's true, but this establishes where the focus of this witness was, and if he noticed
Yeah.
what happened to Mr. Doe
This-
in that given time.
This does go to the quality of the witness's perception of the events. It's relevant.
Very well.
So, I had been primarily focusing on Mr. Angelo after they had tased Mr. Doe, as Mr. Doe had been tased and cuffed.
Okay, but to
and I
clarify,
deemed that it was not
the
relevant.
officer that you said was dealing with Mr. Angelo stopped dealing with Mr. Angelo and went after the defendant.
Yes, I believe Mr. Jetty Jakowski left it to Micah Devon. Finished it off with Mr. Doe.
I thought. Okay, maybe I'm confused, but you said Officer Peralta was dealing with Angelo and Officer Peralta left.
Yes. Mr. Peralta walked away from Angelo or looked away. It's hard for me to remember which one it was. Mr. Angelo got out of the car, began backing up. I shouted for him to stop to try to alert the officers, not intending for it to be a lawful order. Simply as a civilian, telling him to stop. I mean, it's in his best interest in the first place. At which point,
So the
Mr.
officers-
Peralta began to... I'm not finished. Mr. Peralta began to run over, but Mr. Jetty Jakowski had ran over quicker and very quickly tased Mr. Bobby Angelo.
Well, you're not answering my questions. You're reading your affidavit, because that's verbatim what you say in your affidavit. So,
What's worse is I have the penal code up on my third monitor, so I am in fact not reading it. That is just exactly how I remember it.
for the record, Your Honor, I'd like to make note that those are verbatim the words in the affidavit, and as he says, remember it exactly there as, but this is, again, on-stand testimony. The point of an affidavit is to see consistency. Reading an affidavit would be another matter. So just making note of that.
Okay, so noted, but I mean, that alone is not sufficient. I'll warn the witness, of course.
The prosecution would like to know that could just also mean that it's
Yeah. Well, and I'm getting
The same
there.
thing.
I'm getting there. Prosecutor is, on the other hand, inconsistencies are being attacked and consistencies are being attacked. It seems like there's maybe no safe harbor here. Unless you can show that he is looking at it now. Let's just move along.
Well, that's my, just to be clear in my argument, the reason why we're noting it here is if it's brought up again, we'll bring this back up. And I understand if
Okay.
consistencies are
That's
being
fine.
attacked too.
I understand. Let's move on.
So you were focused on Bobby Angelo. You did not see exactly, at least with clarity, what happened to Mr. Doe.
After Mr. Doe was tased and handcuffed, no, I did not pay attention to him. I primarily focused on Mr. Angelo, who was.
So Mr. Doe was tased in handcuffs before you stopped paying attention to him.
Correct.
And that's when you noticed Bobby Angelo walking away calmly, as you state in your affidavit.
Mr. Angelo was in fact in the car during the cuffing and tasing and had gotten out in the middle of it, but I could very clearly see the officers putting handcuffs and hear it from the distance.
But you said earlier that Officer Peralta ordered him out of the car and waited there with him and then left once Doe became more of a significant issue. Is that not true?
I said he either left or he looked away. It's hard to remember off of memory as it's such a small
I'm
detail
going to go
that I wasn't really paying
objection
attention.
asked and answered. This has been addressed previously in this testimony. This is only elongating the cross.
I mean, did he ask this in cross already?
I didn't ask if Officer
It's been addressed
Peralta...
previously.
Okay, even if it's been addressed previously, if it hasn't
said
been
it,
asked in
I
that
asked.
particular examination, it's fine. Overruled.
Okay, so you said you weren't sure. So you're not sure of the events that took place during the arresting of Doe and what Mr. Peralta did and Angelo.
No, what I said is I am unsure if Mr. Peralta had ran over to assist with Mr. Doe or if he had simply looked away. It is such a small detail that I physically cannot remember it. That's like asking me which hand did I wipe my ass with last night. I don't remember.
Come on, Collins.
No.
I get that we're frustrated about.
Sorry,
being
it's the
so
only
late,
way.
but
It's
let's
the
just-
only way I could describe it. Okay, I'm sorry. It is
Yeah.
literally just such a small detail that it's hard for me to remember
All right.
which he did.
Come on, let's just.
Well, it's not a small detail. Whom you were paying attention to. See,
I was
That's
paying
just
attention to
making a
Mr.
statement on its
Angelo,
own. Once
just
again, the
not
Yeah,
argument
Peralta.
negative.
that's stricken. Counsel can't testify.
So is it fair to say that your memory of the event not 100% clear?
That is very odd to put it, and I'd say it's pretty inaccurate. I can remember most details, just not the small details. I mean, you're a lawyer, I'm a lawyer. We both know witness testimony is not perfect. I mean, it's as simple as that. I just can't remember the smaller details. I mean, that's just how it rolls with witness testimony. The smaller details of why I did this, the way I drove, the way he was looking, or if he was running over to Mr. Doe. They're all very small
Smaller
things that I
detail-
consistently can't remember.
Yes, and clear, the smaller detail you cannot remember is if while Doe was being cuffed and restrained, you don't remember that Peralta was either by Mr. Angelo or helping Doe restrained.
Correct, because Mr. Peralta was not in my view. He was just barely out of my peripheral view. I was looking towards Mr. Doe, which also enclosed looking at Mr. Angelo.
You said Mr. Angelo was in by the front door of the car because he's hopped out, and you said Mr. Peralta was standing in front, asking him, ordering him to get out.
Mr. Peralta was in my peripheral view. He was at the car at the time, the entire time, asking them to get out. And then I looked slightly over to the left, looking at Mr. Doe, and that's when he got mainly in my peripheral view, and that's why I cannot remember.
And at that point, Mr. Doe was arrested, and once you drew attention, the other suspect.
I'm
Mr.
sorry, could you
Angelo-
restart that over? This question is
the
very
prosecution
confusing.
would like to strike that as the first bit was just testimony about Mr. Doe being arrested.
I mean, to some extent,
Well, I'm
transitions
drawing-
are allowed in questions. I'm gonna overrule it, but let's keep it.
I mean, regardless, that question was confusing to me. I don't understand
if
what
you
he was
could
trying to
repeat.
ask
Okay,
in the
I'm
first
trying
place.
to draw attention to time to where both defendants, both suspects
I still don't
were-
understand what you're asking me. Could you ask me like I'm a 5-year-old, please?
asked the question. Trying to tell you that what happened when both suspects were restrained.
I'm still so confused by
Your
what the
mic
hell
was
this
kind
question
of
was.
Do you
quiet
understand?
during
you
the end
might
of that.
understand what I'm saying.
No, you are wording it in such a way that I am very confused, which is very impressive to do, mind you.
For
Yeah,
the
you're.
record, Your Honor, were you able to
Yes.
understand the question that I was asking?
You were
I
cutting
was not.
out and quiet. Frankly have no idea.
Okay, I'll try and be louder and restate this. When both of the suspects were in handcuffs, the vehicle, is it true that the vehicle was searched first?
I could not tell you whether or not Mr. Doe or the vehicle was searched first, as Mr. Doe was too far away for me to see them physically searching him. As I said, I was primarily preoccupied with Mr. Angelo at that phase.
But
Hello, is
you
this thing
earlier
working?
said you witnessed the search, correct?
The search of the car?
Yes.
Yes, I believe Mr. Peralta opened the trunk of the vehicle.
And it was Mr. Peralta who took photos, correct?
I believe so.
But you don't remember what you don't remember if actually I'll not ask that question.
The prosecution would like to note that the witness just testified to images 1 and 2 of, let me see the exhibit number,
Okay.
of exhibit 4 in the evidence exhibit.
Yeah, that's fine. I'm not going to acknowledge that on the record because you would need to lay the foundation for that in one of the examinations, which I assume the officer is going to do later. So I'm not going to put that on the record.
And again, he mentioned that he didn't remember this exactly with clarity.
Yes, I was, again, primarily occupied with Mr. Angelo. Do you understand what I'm saying? Do you speak English? No
Yes,
offense.
but you had said that Mr. Angelo was already in cuffs by this time.
Yes, I was
That's
primarily
asked and
letting
answered.
him
He's
know.
just restating what the witness said earlier.
It's okay to confirm a witness's testimony by repeating a fact or an answer back to them maybe once. In fact, it's necessary to perform an impeachment, or full impeachment, I mean. But if it happens again for this question, let me know.
Could you please
So
ask
why
the
were
question?
you? Yes. Why are you still focused on Mr. Angelo after he was cuffed that did not witness the clear timeline of who was searched, what was searched?
I believe it was because of the best of my ability, the officers had me hold him there momentarily by the cuffs while waiting
So
for transport.
officers had you hold him in cuffs?
Yes, I held him by his cuffs, I believe, Mr. Angelo.
So you were assisting officers in the arrest.
As any good civilian would, they would in fact help them since they are the one that was going to give them the right. And at the time, there was no vehicle there present, and the other officers were preoccupied dealing with the rest.
I'm going to reinforce the court's earlier ruling about Mr. Collins and his relation to the arrest. This has been addressed already.
Yeah, I'm.
No, to be fair, you said earlier that we could bring it up in cross-examination, did you not? I believe I recall that the issue wasn't fully quashed.
I said
Was
to
that
the,
not a mention to the black thing?
Well, I said that to the
Yeah, that was-
extent that, yeah, and that's really what it was about, is to the extent that anything goes to bias or to the witness's credibility, it can be brought up in cross.
And he testified to not helping at all earlier. Well, he didn't testify to it. It was established that he didn't. He said no, and now he's... So again, we're just challenging that credibility.
Okay, I mean, yeah, you can, that's true, you can attack that statement, but again, I'm going to caution you to keep that line of questioning
To
where it
clarify,
is
I
pretty
would just
clearly.
like to say,
Okay, well, go ahead.
My next... understood, Your Honor.
I
My
don't,
next
I don't
question
think
is...
that there's a single. Let me just finish it.
I have another question.
I was simply just holding him by his handcuffs. I did not help them handcuff him in any way, shape, or form.
Okay.
I just held him there so that way they could, do their job while waiting for transport.
Okay.
And do you often help officers in their duties?
No, not often.
Not often, but you do.
Occasionally, whenever it comes to the interrogations or helping set up plea deals, I'll help up an officer, but outside of that, I very rarely help physically with the defendant unless they ask me to.
But you don't ever assist officers in the actual stopping or detainment of the defendants or suspects.
No, not to the best of my memory.
So earlier in court, when that individual was trying to leave, you weren't stopping or assisting the officer in the courtroom
Did you
with the
see me
detainment?
actively pull my fist out, a pair of handcuffs? I was simply trying to block the gentleman so that way he could stop impeding the court. It was getting on my nerves.
and that's not
Because he had already
assisting,
done
in
it
your
once.
opinion.
No, that's just basically helping out. I mean, it barely even did
I'm
anything
going to object
for the
based on
officers.
relevance at this point. The
Yeah,
ongoing
counsel,
earlier in the
move on.
court of the minge bouncing around.
Yeah, move on.
Well, I believe it is
Move on.
relevant, and I'm just.
I mean, if you want
the
further, if you want
Okay.
further
Dude, just
clarity,
move on.
there
This
was
has been
literally
going on long
only
enough.
And I don't
one
need
officer
anything,
in the
I don't need
entire
anything else from the
courtroom.
witness, okay? Just move on.
Okay. All right. That is all my questions.
All right. Which case, redirect from the prosecution.
Just a brief redirect. It won't be as long.
I'm praying on brief.
I swear to God, if this leads to another cross, I'm gonna. That lasts another 30 minutes, bro.
Hey, no comment,
There's
no
not
comment.
Gonna be,
No.
There's not going to be a recross unless there's some very significant need for it.
Okay, just to clarify the course of events. What happened once Mr. Doe and Mr. Angelo entered Mr. Doe's vehicle?
They both opened up the trunk. One of them, I believe, Mr. Doe, proceeded to say yours first. And then at that point, the officers hopped out of the vehicle and then proceeded to order Mr. Doe and Mr. Angelo to get out of the motor vehicle. Then Mr. Doe proceeded to flee and was then very quickly subdued by officers by the use of a electrical taser device. At which
And
point,
whilst Mr. Doe was...
I'm not done, I'm not done!
Just to prevent any objections to narrative, I'm going to ask a question to segment this. Whilst Mr. Doe, or once Mr. Doe was being detained, /tased, /cuffed, what was Mr. Angelo doing?
Mr. Angelo was sitting in the vehicle until he finally got out and began slowly backing away when Mr. Peralta was either away helping with Mr. Doe or looking in that general direction. Unclear which one it was based on my memory. At which point, Mr. Angelo continued to walk backwards. I screamed, "Stop walking," top of my lungs, I believe, to alert the officers. At which point, Mr. Jetty Jakowski swiftly ran over and tased him with an electrical taser device. And then Mr. Peralta came over and either Jetty or Peralta put the handcuffs on him.
Thank you, that is all.
Alright. I don't see any substantial need for a redirect or a recross here. So, I'm gonna...
No, Your Honor, but the defense is gonna motion.
Oh, okay.
Oh, brother.
We're gonna motion to strike this witness based off of inconsistent testimony and non-recollection of certain events. When asked, just perfectly
You're cutting out.
recollected a different scenario.
Yeah, you're cutting out.
When asked right now, he gave a different accounting. What other than when we asked him? When we asked him, there was multiple points in times where he could not remember, did not remember, or again, the events were unclear, especially for key circumstances of it. So we are motioning to strike the testimony in the affidavit of this witness.
Denied.
The prosecution, of course,
Yeah. Denied.
Thank you.
Okay. If there's nothing else for this evening, court is adjourned. We will continue the other witness testimonies at a later date. This was really going to be the top one.
Yes.
So.
I'd much prefer Rossi examines the expert as he's still main counsel. I was just filling in for this. We did not speak about me examining Jetty. This is fucking dumb.
And I'm not gonna. Please be careful of the profanity. I've tried to be lax about it, but.
Apologies, it's been a very long night.
Everybody's frustrated, but it's 10 p.m. I'm gonna go have 2 glasses of rum and coke and smoke my pipe. So, I think I've had about enough of this for the evening, and I don't think that continuing this is going to be helpful for anybody, especially while I'm brain fried. So we're going to continue this. For now, though, court is adjourned.
Thank you. Oh, hold on. Before you leave,
Gentlemen,
Your
have a
Honor,
good night.